I'm a partner at Snell and Wilmer here in Phoenix, and I had the privilege to serve as president of the American Bar Association in 2020, 2021, which I'm pretty sure is how I got this gig tonight. But it's really delightful to be with all of you. I'm going to introduce our panelists tonight, and I apologize in advance to them and to all of you that they will be necessarily much too short to convey how wonderful they all are. Starting with Ilan Wurman, who is an associate professor of law here at the Sandra Day O'Connor College of Law. He specializes and teaches administrative law and constitutional law. His writings include one case book, 2 books, and a list of articles that is basically a who's who of the major law reviews in the United States. He's a graduate of the Claremont McKenna College and Stanford Law School. And next to him is Justin Weinstein-Tull, an associate professor here at Arizona State. He teaches and specializes in structural constitutional law, state and local government law, and election law. Before joining the academy, he was in practice at Munger, Tolles & Olson, one of my favorite firms, and the Civil Rights Division of the Department of Justice. He too has an extensive list of publications, another who's who of law reviews and other professional journals. He's a graduate of Stanford University, Harvard Kennedy School, and the Yale Law School. And on the far end is Stefanie Lindquist. Stefanie is the Foundation Professor of Law and Political Sciences here at the Law School and at the the ASU School of Global Politics. She is also the director of ASU's Center for Constitutional Design, which of course is the sponsor for this evening's gathering. Prior to joining the academy, she was at Latham & Watkins, also one of my favorite firms, and the Federal Judicial Center. She's the author of 3 books and the 3rd really extensive list of articles in every important law review that's out there. She's a graduate of Temple University for her Juris Doctor, and she earned her PhD in political science from the University of North Carolina. So this is an amazing group, and what we're going to do tonight is each of them will speak, hopefully in a Q&A session here about...
I brought no notes, so it's better.
So you need my questions, that's good. About this most recent Supreme Court term, and then at the end, Stefanie will talk a little bit about projections and thoughts about the coming term, and assuming we have some time, we'll also talk about the swirling issue of an ethics code for the United States Supreme Court, and we'll save time at the end, if we do this right, for your questions. So we're going to start, Ilan, with you and talk about sort of presidential powers. And you're going to need to orient everybody a little bit in each of these cases because we do not all live them the way you do. So talk about what the major questions doctrine is and how that manifested itself last term.
So to the administrative law students who showed up here for some reason, sorry, this will be repetitive, or you're welcome, I suppose. Reviews are always good. So the major questions doctrine had a number of variants before the 2022 term, but really before the 2021 term. What year is this? 2023? And so the court used it for the first time as a doctrine in the 2021 term. But basically, it's this idea that when you're interpreting statutes delegating authority to agencies, before the agency does something big and consequential, something politically controversial, economically significant, the major questions doctrine says that the court is going to presume that Congress did not delegate to the agency the power to resolve those major questions and major issues unless there's a clear statement, something specific in the statute. So this has come to a lot of criticism Because ordinarily you interpret statutes and you kind of decide what the best reading of the statute is, and if the best reading of the statute authorizes the agency to do this big and important thing, then it authorizes them to do this big and important thing. But the best reading of the statute is not enough under the major questions doctrine. If it's, again, this major political, economic question, we're not even going to do the best reading. We're going to decide it's a major question, look to see if it was clearly and specifically authorized in the statute, and if it wasn't, we're going to say the agency can't do this. So the Supreme Court deployed this new doctrine. I say new, I mean there are antecedents to it, but it's used in kind of a new way, 4 times in the 2022 term. I'm confused about what year it is, but the 2021 term, and then they used it again a couple times in the 2022 terms in the OSHA vaccine and mandate, vaccine or test case, in the CDC eviction moratorium case, in West Virginia v. EPA over the Clean Power Plan, this term over the student loan relief that President Biden ordered, and then arguably Sackett v. EPA, which involves the scope of the Clean Water Act. These were all decided as major questions cases. And so this seems to be this new conservative-ish thing to try to rein in delegations. And maybe this is a way to enforce the non-delegation doctrine, this idea that Congress has been giving too much power to agencies, but the non-delegation doctrine hasn't really been enforced since 1935. And so maybe this is a way for the conservatives to limit the scope of agency power without having to resurrect the non-delegation doctrine and get into something messy there.
And
So,
is that how they justify it in the opinions?
depends who you ask. And there are, of course, also different interpretations of what the different justices say. So it's actually unclear what the justification for this is. Justice Gorsuch and Justice Alito in the prior term seem to say that it is enforcing the non-delegation doctrine, that it's this that the non-delegation doctrine has been under-enforced, and the major questions doctrine is like other substantive canons of interpretation that enforce other constitutional values. But this is super weird, because if that's what this is, this clear statement rule that advances non-delegation values, well, ordinarily, Congress is allowed to do the thing that's in question if it speaks clearly. So for example, there's a presumption against preemption. There's a presumption against abrogating sovereign immunity. If Congress speaks clearly, though, it's allowed to preempt state law, right? As long as you're within its enumerated power. It's allowed to abrogate sovereign immunity, pursuant to the 14th Amendment. It just has to speak clearly. Well, here, does Justice Gorsuch really mean, well, if Congress speaks clearly, then it's okay to delegate these big and important questions? I don't know that he's willing to admit that, right? And so it's a bit weird. So maybe it's this clear statement rule, like other clear statement rules. In Biden v. Nebraska, the student loan case, Justice Barrett, I will say, in Biden v. Nebraska, which is this term that we're supposed to be talking about, they seem to have tempered the major questions doctrine a bit. Okay, so in the previous term, they basically said, okay, is this a major question? It's a major question. Let's look for a clear statement. And there's like a paragraph of statutory interpretation, maybe. Because if there's no clear statement, you're done. It's easy. In Biden v. Nebraska, the student loan case, they did a lot more statutory interpretation. And they basically concluded, I think, that the best reading of the statute precluded the granting of the student relief of the principal debt, the student loan relief. So they basically concluded that as the best reading. And then they added, as an additional consideration, the fact that this is a major question and generally we want clearer statements. So it was like this, just one additional tool. So they seem to have tempered it. And then Justice Barrett, in concurrence, had a whole different theory, one that I actually tend to share, and I've written about it, and it's forthcoming in the Virginia Law Review, that actually a version of the major questions doctrine can be defended as sort of a linguistic canon. It's actually just how people understand language in ordinary context of delegations to agents. It's in the third restatement of agency. It says that too, for the agency lawyers out there, that before an agent takes an act that is fraught with collateral consequences or major legal implications, you would expect clear authorization for something like that. So, and Justice Barrett uses an example that I use in my paper too, about telling a babysitter to go have fun with the kids for the weekend. Here's a credit card. Does that the babysitter to go to Disneyland and buy a night at the hotel, and Justice Barrett says no. And as a new parent, I agree that generally that's probably no. However, there is a flaw in that reasoning in the sense that I think as an empirical matter, Congress does often delegate precisely like that. It delegates, make national ambient air quality, standards sufficient for the or requisite for the public health with an adequate margin of safety. That sounds to me like the babysitter, go to Disneyland. I'm tired of parenting. You figure it out, right? That's really how Congress legislates. Now, I think it's more defensible in certain other cases because in a lot of these cases, the statutes are genuinely ambiguous, and I don't think Congress does big, major things through ambiguities, but this is just an old canon of interpretation that Justice Scalia used to describe as Congress doesn't hide elephants in mouse holes. It's like, if Congress is going to do this big thing, it doesn't do it through cryptic language. Usually it tells you, right? But sometimes Congress doesn't use cryptic language. Do what's fair and equitable. Do what's just and reasonable in the public interest. So there are many delegations like that. And so whether the linguistic defense works all the time is, I think, an empirical question of how Congress operates in the space.
So what does this line of cases portend for other administrative law doctrines like Chevron and non-delegation? What's your prediction about where this is all going?
So they have a Chevron case coming up, actually. But it just seems odd to me, like, why do they need to even take the Chevron case, since it's quite obvious that Chevron is dead at the Supreme Court? Now, okay, maybe I spoke too soon, because Chevron does seem to matter at the courts of appeal, and maybe the Supreme Court really wants to say, no, it shouldn't even matter there. So I don't quite know what's going to happen with Chevron. But the thing about the major questions doctrine is, historically, all of these cases would have been Chevron cases, because they all involve statutory ambiguity. The student relief case, right, Biden v. Nebraska, why was the statute ambiguous? Okay, because it says, it gives the president in an emergency situation, and COVID was an emergency that qualified, power to waive or modify statutory or regulatory requirements related to the student debt program. Well, does that give you the power to waive or modify the principal debt, right? I actually don't know. It doesn't strike me as obvious what the answer to that question is. The debt itself is not a statutory requirement with respect to the debt. It's just the debt, right? And the statute also says you can waive or modify to ensure that the borrower is not worse off financially because of the emergency. Well, if you get rid of the principal debt, in a way they're not worse off. They're better off, right? But it seems clear to me that that's not what the statute intended. It's like, okay, suspend interest accrual, suspend interest payments or something. That makes sure they're not better off. But at the same time, if you make them better off, you've made doubly sure that they're not worse off. So historically, this would have been a Chevron case. Not a single mention of Chevron. Do you all know what Chevron is, by the way? I should have probably started with that. Whatever, I'm going to assume you know what Chevron is. They would have deferred to the agency's interpretation of the statute. That's what Chevron is. But none of the parties mentioned Chevron. None of the opinions mentioned Chevron. It's just dead. So not only is the Supreme Court not deferring to an agency's interpretation of an ambiguous statute, which is what Chevron requires, but it's not even going to give the statute the best reading. It's going to demand a clear statement. So it's like doubly reining in the previous Chevron deference regime, which again, ending with what I should have started with, this regime whereby courts defer to agencies' interpretations of their ambiguous statutes.
Right. So you mentioned, the Sackett case, which I'm mostly interested in because it's the second time these people have been to the United States Supreme Court. I mean,
it's been 20 years they've been litigating this.
There aren't that many folks who have had two cases before SCOTUS. So tell us about this most recent Sackett case and what it means.
Yeah, this is an example of the agency should have picked its battles. And I really don't know why the EPA really wanted to go after the Sacketts. But the Sacketts just bought a piece of land near Priest Lake, Idaho, I think. It is never wet. It is nowhere near water. And the EPA decided that it qualified as waters of the United States. Why? Because under the EPA's definition of waters of the United States, the EPA's jurisdiction, now there's a piece of the statute that seems to imply that waters of the United States can include adjacent waters as well. Well, their property, which again is never wet, is next to a man-made ditch that flows into to Priest Lake, which is an intrastate lake, which itself, I think, spills into maybe the Mississippi or something. And so it eventually connects to a navigable water of the United States. And so the Sacketts went up the first time when the EPA issued a cease and desist order, and they said, every day that you continue building on your land, they wanted to build the house. They were retiring. It's 20 years ago. I guess now they can finally retire. But 20 years ago, they started to build. They got a cease and desist order, and the agency said, we will fine you something like $7,500 a day, or it was something like in the tens of thousands of dollars a day if you continue to build. And then the Sacketts wanted to sue the agency, saying, for a declaration of their rights, and the agency said, well, we haven't made a final decision. This isn't final agency action yet. And the Supreme Court unanimously, 9-0, said, if you're threatening them with tens of thousands of dollars of fine a day, you don't have to bet the farm before bringing a lawsuit to challenge the agency. That's final agency action for purposes of the Administrative Procedure Act. So that took 10 years. Then it went back, and then the EPA kept at it, and they said, okay, we really mean it. It's final agency action, we get it. And then the merits of the question is this dry piece of land adjoining a ditch, adjoining a lake, and adjoining a navigable water, part of the waters of the United States? And so the Supreme Court said no, it's not. And this actually was unanimous. It was a divided opinion as to the reasoning. The majority's reasoning went much farther than Justice Kavanaugh and the liberal judges would have gone in their concurrence. They said you need a continuous surface connection. Justice Kavanaugh thought that adjacent meant, you could be separated by like a natural barrier or a dike or something like that. Either way, this didn't qualify. But the major questions doctrine is somewhat implicated here because it was argued that if Congress really gave the EPA this kind of authority, then it would reach all the way into the interiors of the state, like it would supplant state police power, and something big and important like that ordinarily demands a clear statement. It's sort of, again, this federalism canon meets the major questions doctrine. Actually, a lot of substantive canons that you may have learned about are arguably versions of the major questions doctrine. Like the canon against, we're going to presume Congress didn't mean to violate international law. Because it's a big freaking deal if Congress intended to violate international law. So we're going to presume they don't, right? The rule against lenity, rule for lenity, right? The rule of lenity, it's the preposition I was looking for. The rule of lenity, because it's kind of a big deal to send someone to jail for 20 years if the statute's ambiguous, right? That's kind of a major deal to them anyway, right? And so I wonder if a lot of these substantive canons, which a lot of people think are inconsistent with textualism, could be reconceptualized as textualist canons if Justice Barrett / Ilan Wurman are right about this, being able to justify it as a linguistic type canon in certain circumstances.
So what you're saying is that those of us who got law degrees before yesterday may have to relearn everything in the coming years.
Oh, yes. Oh, yes.
Well,
but to be fair, everything you learned was wrong. Okay, and so, now it's just the chickens are coming home to roost.
All right.
So,
I know you wanted to talk about United States versus Texas. So again, orient us a little bit on the case and go from there.
Yeah, so originally I didn't want to talk about this case, and then I reread it. I'm like, actually, I do want to talk about this case. It's pretty interesting. This is one of the many lawsuits that Texas filed against the United States to get them to enforce more immigration laws. Why is this a big deal, by the way? Because of a case out of Arizona from 10 years ago, 11 years ago, where we passed a law, SB 8? No, that's Texas, sorry, SB 12. Thank you. You've all been here a lot. Where basically they made it a state crime to violate federal law, right? If the feds aren't going to come in and enforce the immigration laws, then we can. And the Supreme Court of the United States, in a fractured opinion, I think it was 5-4 with Justice Kennedy writing, said you can't do that. This is exclusive federal domain. And if they choose not to enforce the law, too bad. You deal with the consequences. And so in this case, there, however, is a federal law. Part of the immigration law says that certain types of aliens, the statute uses the term aliens, shall be detained. and the DHS, pending removal, and DHS promulgated a rule that basically said, well, we're only going to detain a subset of those people, those who have known terrorist activities or particularly violent criminals, but there's a huge swath of these individuals who under the statute must be detained, but they're just not being detained. And so Texas sued, and the Supreme Court basically held that Texas doesn't have standing, which is super weird. It's super weird because obviously Texas has an injury in the sense that it bears the brunt of the costs of the illegal immigration coming through Texas. Okay, now it's trying to redistribute that cost throughout the country, through the new busing program, I guess. But it obviously has an injury. Certainly, the key case, Massachusetts v. EPA, where Massachusetts sued the EPA to force them to regulate greenhouse gases. The Supreme Court in 2007 found that Massachusetts had standing, had an injury, because its coastline might decrease by a foot or whatever in the next 50 years. If they had standing, obviously Texas had standing. So there was a fractured opinion about why exactly this was not justiciable. Is it standing? Is it redressability? But redressability is sort of part of standing. So they were all very confused. And on the merits, they basically said, well, enforcement discretion, whether it's standing or on the merits, courts can't get involved in enforcement discretion. There's limited resources and so on. But then the question is, why is Massachusetts v. EPA different, right? The decision not to regulate greenhouse gases is their decision about how to enforce the statute. But that was compelled. The court said you have to regulate. And so Justice Kavanaugh, in a footnote, dispenses with Massachusetts v. EPA, which is like this whole, what it was litigated around, and says, well, that was enforcement discretion. But from the point of view of administrative law or administrative theory, it's all executive power, right? The decision not to promulgate a regulation is no different than the decision not to prosecute somebody, right? Why are those different? And the Supreme Court just sort of glossed it over, probably got it right. I'm not sure they got it right, but they probably got it right. But if you think that the Supreme Court probably got it right, then it probably got Massachusetts v. EPA wrong. And I think that's what Justice Alito was trying to say in the dissent, which is like, I think we've just overturned Massachusetts v. EPA and nobody's talking about it. So just very interesting to watch for whether states are going to have standing and enforcement discretion.
Right, absolutely. So before we get to Justin, I'm going to engage in something that is fraught with peril. I'm going to introduce dignitaries in the audience, which means I will miss somebody and be embarrassed. But Judge Susan Bolton of the United States District Court is here with us, as is Mary Schroeder of the Ninth Circuit, and we're delighted to have both of you here. And if there's someone else, I apologize if I missed you. So Justin, let's start with Students for Fair Admission versus Harvard. Remind us all, we probably all know, but remind us.
Okay.
And take it from there.
Sure. So this case, Students for Fair Admission versus Harvard, is about whether affirmative action programs in admission policies are constitutional, or whether they violate some constitutional law, the 14th Amendment of the Constitution, or for private institutions, Title VI of the Civil Rights Act. And historically, the court has said that universities can do affirmative action programs in particular ways to make them constitutional. And even as recently as 2016 in Fisher versus University of Texas, the Fisher II opinion, the court had upheld an affirmative action program. So what was going on in these universities? So this organization, Students for Fair Admissions, sued Harvard and the University of North Carolina for unlawful racial discrimination in their admissions policies, and in particular for having admissions policies that classified on the basis of race, basically that treated applicants of different races differently. And that sort of goes to the crux of the Equal Protection Clause of the 14th Amendment, which says we can't treat people differently on the basis of race except for some very, very, very special circumstances. And both of these schools had been engaging in some form of affirmative action whereby they would give admissions advantages to applicants of certain underrepresented minority status, race or ethnicity. to varying degrees. But they both sort of admitted that they did so. And the group alleged that that classification violated the 14th Amendment right to equal protection. And the court changed its mind from what it had sort of historically held in these cases. So in Grutter versus Bollinger back in the early 2000s, in Fisher, the court had said, okay, yes, this might be a classification on the basis of race, and we don't love it, but because these programs are meant to sort of uplift racial minorities and not harm racial minorities, we're going to apply a standard that we call strict scrutiny, but it's going to be a little bit easier than most of the strict scrutinies that we apply, right? Something like strict scrutiny light. And using strict scrutiny light, it had upheld these programs in Michigan Law School and in Texas. And in the Harvard case, the court says, well, actually, we weren't really applying true strict scrutiny. We were giving these institutions a little bit too much deference. And we're going to now sort of go back and take ourselves at our word and apply actual strict scrutiny. It doesn't matter that these programs are meant to help rather than to hurt, right? We are going to, classification on the basis of race is classification on the basis of race, and we're going to apply strict scrutiny. And whereas previously the court had said, okay, the diversity of a class, of a university class, is going to be a compelling interest that might actually justify constitutionally affirmative action programs, the court said the way that Harvard and UNC are doing it is not a sufficiently compelling interest. And the reason why the court said was that these theories of diversity aren't quantifiable. No court can say whether they're working or not. And these programs don't end. They sort of go on. And the court is sort of so uncomfortable with classifications on the basis of race that if it is going to uphold them, it wants to make sure that they don't go on forever. So the court struck down the Harvard and UNC admissions policies.
So, I mean, how far do you surmise this goes? I mean, every large law firm in the United States right now is reevaluating its own, for example, internal clerkship programs, et cetera, to figure out whether they comply. And as you know, several have been sued, claiming that their programs don't. I mean, how far does this go? Is any affirmative action allowed anymore anywhere?
It's a great question, and it's a question that we don't know the answer to.
Well, that's not fair.
Yeah.
What is the answer?
So it is certainly true that the lawyers behind the cases that challenge affirmative action policies want to challenge affirmative action policies that go as broad as possible, right? They want to get rid of all affirmative action policies, whether they're in universities or in state government or in federal laws or in law firms, right, or in private corporations. I heard the other day that even the NYU Law Review was recently sued because of the way that it chooses its members. I don't even know what kind of a legal organization the NYU Law Review is. Is it an educational institution? Is it an employment institution? I actually don't know. I mean, maybe we'll find out. So I think that the lawsuits challenging affirmative action programs are going to be aggressive and they're going to be broad. We already know that. How far the Harvard case extends, I think, is up for grabs. And it's up for grabs in the legal community as well. So there are folks who think that the Harvard case can possibly be limited to its facts, those facts being the ways in which Harvard specifically and UNC specifically deal with diversity and sort of engage with their affirmative action programs. The court in the Harvard case doesn't explicitly overturn Grutter versus Bollinger, which sort of was this classic affirmative action case, and doesn't say that it's impossible for diversity to be a compelling interest. So there are some who say that maybe we could sort of limit Harvard to its facts, and it's possible that there could be some programs that are affirmative action programs that could be upheld. I'm very skeptical of that. My sense reading the Harvard opinion was that the court wanted to be done with racial classifications of this kind. And there is a fascinating, if you haven't read the opinion, I would encourage you to go read it. There's a fascinating back and forth between Justice Thomas and Justice Jackson. Justice Thomas in concurrence and Justice Jackson in dissent, where Justice Thomas expounds his view, which he has a number of times, that affirmative action programs, although they might intend to be benign, affirmatively harm racial minorities. And then you have Justice Jackson in response saying that affirmative action programs remedy long-standing and still existing racial discrimination and racial injustice in the country. And there really hadn't ever been that back and forth in the court in the context of these affirmative action programs. So that to me really stood out. But I think this court, Justice Roberts, Justice Thomas, is really uncomfortable with racial classifications. And so my guess is, absent a change in the court, which is always possible, this will expand in the near future. Yeah.
Well, the two worldviews that you just articulated are both basically result-driven. I mean, if you hold one view, you go one place in terms of the answer, and if you hold the other view, you go to another, right?
Yeah.
Isn't that fair?
I think so. And I mean, I think this is also a court that, I mean, as Ilan said, although not in these exact words, is an extremely creative court. This is a court that is
They're conservative. They conserve what exists.
They're an extremely creative court. They're an extremely industrious court. And they're a court that is not afraid to disrupt. And so I don't think the court is worried about overturning the Grutter precedent and the Fisher precedent. And so I guess when you say outcome-driven, my head sort of goes to, well, is there doctrine to grab onto that can guide us? And I think the answer is no, because I don't know that there's that much interest in the doctrine.
Well, I mean, what I was trying to say was if one starts from the premise that any racial preference is a horrible thing and bad, right? Versus if you start from the premise that some racial preferences benefit the group they're intended to benefit and remedy, evil discrimination, it's hard to come out to a different result from where you start.
No, that's right. And also, I mean, and this has been a discussion in 14th Amendment equal protection going back, now decades, right? Whether the 14th Amendment prevents all classifications on the basis of race or only classifications that seek to harm. And Justices Sotomayor and Justice Jackson in dissent both go back in history to laws that classified on the basis of race, but in ways that were intending to lift up and not to harm. And that historical evidence, doesn't convince the majority.
Right. Yeah. Right. All right, let's talk about Moore versus Harper, and
Sure.
again, orient us a little bit, and then
You got all the juicy cases.
talk about the practical effect of this opinion in the real world we all live in.
Okay, so Moore versus Harper, and actually also Allen versus Milligan, the other case that I'm going to talk about, are both cases that sort of made voting rights practitioners kind of exhale, because they both had the potential for massive change, and the court sort of stepped back and didn't cause massive change in the way that it has caused massive change in some areas. So Moore versus Harper, these election law cases, the facts are just outrageously complicated, and I don't want to bore you with them. But the basic facts in Moore versus Harper are these. So North Carolina, every 10 years there's a census, and states have to redistrict, right? They have to change their district lines based on whether people have moved into the state or moved out of the state, whether people have moved in or out of different cities. So North Carolina was engaging in its redistricting for its congressional delegation, and the body that does that is the state legislature. So the state legislature has control over congressional districts, right? That's actually a fair amount of control that states have over federal elections. And they had enacted this map. And the North Carolina Supreme Court heard a challenge to that map under state constitutional law and struck down that map under state constitutional law. And then there was some complicated stuff. But that opinion, that North Carolina Supreme Court opinion, made its way up to the Supreme Court in the form of Moore versus Harper. And the allegation that the map makers, the state legislators, made at the Supreme Court was, actually, it is only us, the legislature, that gets to decide on these maps. State courts don't get to butt in and strike them down. And so the question is, can state courts strike down state law on the basis of state law? And that seems like a really easy question, because in every context we would say, of course state courts can strike down state laws on the basis of state constitutional law. But the twist here is that there is a sentence in the Elections Clause of the United States Constitution. So let me just read you this sentence. The sentence says, the times, places, and manner of holding elections for senators represented. Times, places, and manner. So the guts of the election, right? Like how we are going to organize this election, shall be prescribed in each state by the legislature thereof, right? So you have a line in the Constitution that says how to run elections is left up to the state legislature. And so the legislators took this to the Supreme Court and said, this is our power, this is our responsibility. The US Constitution says so. The state court needs to sort of stay out, and we need you, the Supreme Court, to tell us this, right? So this is what's known as the independent state legislature theory. It's a theory that's sort of been around for quite some time, although it hasn't really ever been adopted in a full-throated way by the judiciary. And well, we can talk later about why it sort of became more salient, but basically the Supreme Court said, no, judicial review is important. It's a part of our system, not just federal judicial review, but state judicial review. And so long as the state court is engaging in normal judicial review, we're going to allow state courts to strike down state laws, even in the context of elections and election administration.
I think I'm
yeah,
right
go
on
ahead.
this, but I think the National Conference of Chief Justices filed a brief in this case, and I think it was the first time in maybe forever that the conference had filed a brief.
Sounds like an advisory opinion.
So the weight of individuals on the side of rejecting the independent state legislature theory was massive. And there were a few folks on the other side, a few scholars whose papers had been really sort of heavily disputed, and I won't say debunked, but disputed by others. But I would say many legal authorities were sort of saying this actually would be crazy if you adopted the independent state legislature theory.
And so they didn't.
They didn't.
But related to this is the Allen versus Milligan case.
Yeah, but actually, if you wouldn't mind, if I could mention one more thing
Sure.
about Moore versus Harper. So, everyone sort of exhaled, but then, as the court often does, it inserted a few paragraphs at the very end, which everyone is now very anxious about. And those paragraphs say that state courts can't transgress the ordinary bounds of judicial review, such that they arrogate themselves the power vested in state legislatures. So, like the court generally does, it gave itself power, wiggle room in a future case to step in and say, yes, in general, state courts can't do this. But here the state court really overstepped what judicial review is, and it took that power. And part of the reason why people were so concerned is that there are many state legislatures around the country that need checks and balances, right? Let's put it that way, right? They need the checks and balances of
You're so polite in the way you say things.
Of their state courts, of their executive branch. And during COVID, I think part of the reason why this became so salient, during COVID, it was very difficult to get out and vote for some people, right? And so state executive branch officers did things like they sent absentee ballots to people to everyone, even if you hadn't signed up for it, right? This pissed a lot of people off because, for a whole lot of reasons, right? But this was also a totally reasonable response to a pandemic, right? That completely changed the way we did everything, including voting. So the independent state legislature theory sort of became reborn during COVID, I guess, is what I would say, and found its way to the Supreme Court in this particular opinion. And the court said, okay, we're not going to do it.
All right, so Allen
versus Milligan. Okay.
A 5-4 decision that was splintered opinions on both sides.
Yes.
These were all opinions in which, so-and-so joins except in Part 3B1, and so-and-so joins except in Part 2C F
Oh, yeah,
or
right.
whatever.
Yeah.
It's like a religion clause case.
Yeah,
Explain
it's
it
very irritating to piece that apart and to teach and et cetera, et cetera. But
But that's your job.
that's my job, and also the court can't get it together to agree on things, you know. But anyway, okay. So whereas in the Harvard Students for Fair Admission case, the court was uncomfortable with racial classifications, the court in Allen versus Milligan upholds a law that prohibits discrimination on the basis of race or color. And interestingly, you have argument. Well, let me sort of set this up first. So this case is a case that resolves a dispute about Section 2 of the Voting Rights Act of 1965. Voting Rights Act 1965, huge transformative law. It brings the vote to millions of people who had previously been denied the vote on the basis of their race or color. It transforms the South. And it's one of the two sort of big pillars of the Voting Rights Act. For context, the Supreme Court struck down the other big pillar of the Voting Rights Act in 2013 in a case called Shelby County versus Holder. So when the court took a Section 2 case, there was a lot of concern that that was going to be the end of Section 2, right? And potentially sort of maybe sunsetting the Voting Rights Act altogether. Section 2 prevents vote discrimination on the basis of race or color, meaning that it prevents a whole lot of things. It prevents vote denial, it prevents vote dilution, it prevents racial gerrymandering. One of the things it prevents is abridging the vote, and abridging the vote can happen around districting. So just to give you sort of a very dramatic example, if you have a jurisdiction, let's say you have a state, and 40% of the voting age population is black, but through gerrymandering or whatever, there are no black representatives. The court is going to be very concerned that that's an abridgment of the right to vote in violation of Section 2 of the Voting Rights Act. That doctrine has been around for ages, since 1965, and then when Congress reaffirmed Section 2 in 1982. And so here there was a sort of, Alabama had to redistrict. They redistricted in a way that created one majority black district. A lawsuit was brought saying that there should have been 2 majority black districts. And the district court, I mean, Section 2 cases are so complicated. The district court had a 200-page opinion that was deeply involved in the facts and found that there was a Section 2 violation. So this then comes up to the Supreme Court. And I think to everyone's surprise, the Supreme Court affirmed the district court. And said the district court faithfully applied our precedent. Now remember, this court doesn't seem to me to be actually that concerned with precedent. So I was surprised to see that this was meaningful for the court, but it was meaningful for the court, and basically kept Section 2 where it is, right? So it's sort of a status quo opinion. I'll stop there for a second. Yeah.
All right. Well, talk if you would just a little bit about Kavanaugh's concurrence.
Okay.
And why that is important to
Okay.
matters.
So Kavanaugh is the 5th vote for a majority here. And Roberts writes the majority opinion. Kavanaugh's is the 5th vote. And in Kavanaugh's concurrence, he says, I'm worried about Section 2 of the Voting Rights Act because it's a race-conscious law, right? Remember, I said the Supreme Court is very anxious about laws that are explicitly race-conscious. In the sense that it says you can't discriminate on the basis of race or color, right? Not such an awful thing. Actually, that's a wonderful thing. But that was enacted in 1965, and again, it was reaffirmed in 1982. And Kavanaugh says, okay, if we're going to take a race-conscious approach, it really needs to be necessary, and it is a long time since 1982. And it might be that Congress is no longer justified in passing the Section 2 of the Voting Rights Act. However, Alabama didn't bring that argument, didn't bring a sort of length of time argument to say that it's now unconstitutional. And so I'm going to leave it there, right? But that's like a loaded gun, because you have the 5th vote of this opinion saying, okay, but there was one argument that they could have brought that maybe they would have won, and if they had brought it, then I might have been persuaded. So what does Alabama do? They ignore the Supreme Court decision, right? Because they think, I'm going to bring this back up. We're going to bring this back up to the Supreme Court. We're going to get Justice Kavanaugh on board this time. We're going to make this length of time argument, and we're going to win our case. It didn't actually happen. The court denied cert. And it stayed down at the district court, where the district court said, no, you have to make this second district. But when I saw that Kavanaugh concurrence initially, I thought, okay, he's inviting a particular challenge. He did invite the particular challenge, but it didn't work out.
He didn't bite, at least on the,
He didn't bite
the second
yet.
try.
Yeah,
Yes.
right, exactly. Exactly.
Right. All right, Stefanie, let's turn to you and let's start talking briefly about 303 Creative,
Okay.
which was clearly one of the major cases last term.
Yes, this is a First Amendment case. You're all aware of the Masterpiece Cake Shop case that was decided several terms ago that involved the Colorado Public Accommodations Law. And that is a law that defines public accommodations very broadly and requires that individuals and companies that are providing public accommodations, including businesses that serve the public, may not discriminate on the basis of sexual orientation. And that statute in Colorado is enforced through the Colorado Civil Rights Division and the Colorado Civil Rights Commission, which is an administrative agency. So in some ways, this case has administrative law overtones, I think. And in the Masterpiece Cake Shop case, the commission, the Supreme Court reviewed what the commission had done and concluded that the commission had unfairly charged the cake shop owner, who had refused to provide a cake to a gay couple, had unfairly treated that individual in the process of the administrative review because they had not respected his religious objections sufficiently. And so that was really a case of free exercise in many ways. This case, 303 Creative, involves a woman who creates websites and wants to, actually. She hasn't done so yet, but she is planning on building a business that creates websites for weddings. And she concluded that based upon what the Colorado Commission had done in the Masterpiece Cake Shop case, she was concerned that if she did start this business, that she would also be brought before the commission and charged with violation of the Public Accommodations Law. Now, one thing to be aware of is that the Public Accommodations Law is not a criminal statute. There's no criminal consequences. There are civil consequences, and some of those consequences are quite mild. They have to, for example, put a description of the Public Accommodations Law in their business or on their window, and recognize and acknowledge its limitations. But so she brought this suit challenging the application of the Public Accommodations Law to her planned business, in which she was concerned if a gay couple came to her and wanted a website, that she would be obligated to provide that website. And she had religious objections to that. She has religious objections to gay marriage. And so she brought the suit, and the Supreme Court really decided this not on religious freedom grounds. I think it's very important to realize that. This suit is in many ways very analogous to the Boy Scouts case versus Dale, which you may remember from many years back, in which the Supreme Court said that the Boy Scouts did not have to accept into its organization a gay scout leader on grounds that was inconsistent, homosexuality inconsistent with the principles of the Boy Scouts. And the Supreme Court sort of found that the Boy Scouts had the right to have their own message, right? And freedom of association also underpinned that case. And so what they decided here in the 303 Creative case was that website building, and the way she was going to do it, is an expressive act. She is making an expression that is in the form of that website, and that forcing her to speak on behalf of a gay couple, which would be required if she was forced to provide them with a website, violated her First Amendment rights. So this is really a free speech case and a coerced speech case, in the sense that if the Public Accommodations Law had been enforced against her, she would be coerced into creating a website that was an expression of a belief she did not believe, or at least was emblematic of a belief with which she disagreed. And so what's left now, I think, from this opinion, is to be resolved is what is expressive speech in the context of a business. Is building a cake expressive speech? Certainly a website might be viewed as such, but there's many other things that businesses do that have some creative or expressive element within them. And where the Supreme Court is going to draw the line between businesses that can be affected by the public accommodations law and those that cannot be remains to be seen. So this is the first, or one might say second case, both involving, by the way, the poor Colorado Civil Rights Commission. They are getting beaten around the head and neck by the Supreme Court in the first case for their actions against the cake shop owner. In this case, for actions they have not yet taken, but that she suspects they may, and thus she was granted standing as well by the 10th Circuit to bring this claim. So I'll stop there.
Well, this has been a wonderful discussion about last year's term. So let's turn to this year's term, because some of it is a little bit buckle your seatbelt potential, right?
Oh, yes.
So talk to us, Stefanie, for a minute about what you think are the three arguably most significant cases on the docket for this term.
Yeah, buckle your seatbelts. This is really a potentially very interesting term with some very important cases that will emerge from it. And I have sort of concluded that there are three areas within multiple cases, within a couple of cases in each, that we're going to see some considerable precedent built. The first is in the context of the Second Amendment. And you may have heard that, actually there are two cases here. One involves a federal law that prohibits the ownership of a gun when someone is subject to a domestic violence order, protective order. And Mr. Rahimi is a violent person. He, as I was describing to someone earlier today, he shot up a bunch of things, a car, a house. He shot into the air his gun when at Whataburger, do you know what Whataburger is? It's great hamburgers in Texas. His friend's credit card was denied, so that was grounds for shooting into the air. The police got wind of what he was doing in terms of shooting his gun everywhere. They went to his house, they searched the house, and they found the protective order. And so he was charged under a federal statute that prohibits someone who's subject to a protective order from owning a firearm. It's Section 922 of the Federal Criminal Code. And so he was convicted of that, and he challenged that conviction on grounds that the statute is a violation of the Second Amendment and that it should be eliminated or invalidated on its face, not just as applied to him, but on its face completely. And the Fifth Circuit, and by the way, watch for the Fifth Circuit. The Fifth Circuit is all over this term. A lot of the cases that are going to be decided in this coming term are out of the Fifth Circuit, either because litigants who have very conservative cases to bring or test cases to bring think that the Fifth Circuit or Texas is a good place to start, or because the Fifth Circuit is a very conservative circuit. Either one, there's a lot of very interesting and in some cases extreme cases coming out of the Fifth Circuit. So he challenges this statute in court, and the Fifth Circuit concludes that there is no historical precedent under the Bruin ruling of last term. There's no historical precedent for a statute in the United States back to the time of the framing that protects or that mandated the eliminates the right of someone to own a gun if they're subject to a protective order. I highly recommend this decision. If you want to understand the consequences of Bruin, which is the decision from last term which required statutes subject to Second Amendment review to be compared to statutes or other laws that were in force at the time of the framing, this is a great example of that. This case is really quite eye-opening about how much history is going to matter in Second Amendment cases and how difficult it is to discern whether it applies. So in this case, for example, they're going all the way back to Blackstone, of course, but also to surety laws, which were laws back in the 18th century that allowed someone to basically get a bond from a court if they're concerned about someone else in the community attacking them. So they would force that person, the violent person who they're concerned about being the victim of, to post a bond and pay amount of money if they actually go forward. So it's not a protective order in the classic sense. And the court concluded that that wasn't a good enough precedent in terms of a statute protecting or that allowed the confiscation of guns under the Second Amendment because it was a money consequence rather than a confiscation of guns consequence. This is the kind of thing that's all over this opinion, and I highly recommend it because the Supreme Court's going to have to decide how far it's going to take its protection of Second Amendment rights in the case of a very, very violent offender who, no doubt, his potential victim had reason to get a protective order against. So that's Second Amendment.
one.
Oh yeah, and
We can all feel really good about that one.
And there's some
what's
fun.
the next one?
Real
Sorry.
quick, and one other Second Amendment case. There's a Missouri law called Preserve the Second Amendment Act that commands local law enforcement officers in Missouri to ignore any federal laws that involve, gun ownership. And so this is obviously a Supremacy Clause case, and we'll see how this comes out, whether or not Missouri, that law is struck down under the Supremacy Clause. Okay, 2. My second area I think is so interesting, has to do with the First Amendment and social media. And there are a couple of really interesting cases here. One is a case involving 2 statutes, one out of Texas, one out of Florida, surprise, surprise, called Stop Social Media Censorship Acts. And these acts, again, decision from the Fifth Circuit, and these acts regulate platforms of more than 50 or 100 million users, depending upon what state you're in, monthly active users. And the measures impose restrictions on content moderation. They require a platform to notify a user when content is removed and explain why, okay? And also require platforms to disclose how they moderate and target content. So this is a First Amendment challenge to these statutes, and we'll see what happens there. There's also a case involving a local city manager who is out of Port Huron, Michigan, and he is obviously quite an impressive employee, and he decided on his own to create a website that he would use for many business purposes associated with the city government. So, for example, he had on there the city website, some information about how to contact him and others through the city government. And he also had a bunch of information on there about how the city was managing COVID. And that attracted some individuals who disputed what the city was doing relative to COVID and was posting a lot of things on his Facebook page. And so he blocked that individual. And you may recall this actually happened with President Trump as well. And the question that arose here is he was sued by that individual under Section 1983. And to be sued under Section 1983, there has to be state action. And so the question is whether his website, his Facebook page, was state action. And the issue in the case is going to be whether or not he had a duty to create the website or not, and whether that is the standard to use in determining whether someone's Facebook page is state action, is government action. Remember, he did it on his own. So that's a really interesting case, too, I think, about when someone can be sued for blocking someone else on Facebook if they're engaged in some business activity. And finally, okay, administrative agencies. We've heard a ton about administrative law. Two actual cases. One is the case that Ilan already mentioned that challenges Chevron. That involves fisheries, very exciting. Administrative law cases are all odd, right?
Everyone's misunderstanding that case too, which is super interesting.
Yeah.
'Cause fisheries might make a difference. Like
Exactly.
versus something else.
Even and the question is whether or not the National Marine Fisheries Service, which many of you probably have never heard of, living in Arizona, is what regulates the fishing industry. And under their governing statute, they determined that the fishing industry would have to pay the costs of having observers on their boats to ensure that they're not overfishing, if I can say it as simple as that. And the statute that they use to write a rule that mandates those payments really has a necessary and proper clause in it. It's called necessary and appropriate, but it's really just like the necessary and proper clause. And so that's what they base their rule on. And it went up to, not the Fifth Circuit this time, I forget, the D.C. Circuit. And the D.C. Circuit concluded under Chevron that under either step of Chevron, what the National Marine Fisheries Service did was reasonable, okay, and acceptable, even if the statute was ambiguous. And so that's the case. The fisheries case is the case that makes Chevron vulnerable. And finally, There's a Fifth Circuit case, SEC versus Jarchese. It raises really blockbuster issues in administrative law if you care about this kind of stuff. For example, it asks whether the delegation doctrine, or actually the Fifth Circuit concluded that there was an unconstitutional delegation of power to the SEC because the SEC had discretion as to where to bring its enforcement actions, and there was no constraints within the law about exactly, at least specific enough constraints, about exactly whether and under what circumstances it could bring an enforcement action in the district court or before its own administrative law judges. So we have a non-delegation issue squarely before the Supreme Court this term. It's going to be very exciting to see what happens there because we've gotten some signals from Gorsuch and other justices on the court that they're ready to revisit the delegation doctrine. Also, there is the question of whether administrative law judges who can only be fired for cause that firing language, the for cause language, is unconstitutional because it creates a double layer of protection within an independent regulatory commission. For cause protections for the head of the commission or for the Merit Systems Protection Board members, and then for cause protections for the ALJ. And in previous circumstances, the Supreme Court has held that double protections like that are unconstitutional. Frankly, the bigger picture, I think these kind of cases can ultimately lead to an invalidation, if we have a very courageous court, of Humphrey's Executor, which is a case that allowed independent regulatory agencies to exist in a fight between Congress and FDR. And so it's an old case from the 1930s and allowed those for cause protections to exist for independent regulatory commissions. And I think the Supreme Court hates them and is whittling away at them in case after case. So we'll see what happens with ALJs. Since we have judges in the audience, everybody knows that independence protections are important, whether you're in the federal bench, state bench, or an administrative law judge. And so we'll see what the Supreme Court does here.
Yeah,
And
for sure.
they also said it violated the jury trial right.
Yes, there's also a Seventh Amendment issue. I'm sorry, I forgot that. There's a Seventh Amendment issue because proceedings by the SEC, enforcement proceedings can bring civil penalties, financial penalties. The Fifth Circuit held that those enforcement proceedings must be adjudicated within an within a court that has that has the jury right, Seventh Amendment right, rather than before an ALJ within the commission. Did I miss anything else,
No,
Ilan?
just so everyone understands, the Fifth Circuit found all three grounds to invalidate the agency. So for the Supreme Court to uphold the agency, it has to uphold on all three grounds. It has to say there's no non-delegation problem, there's no Article 2 executive power problem, and there's no Article 3 or Seventh Amendment jury problem. It has to do all of it. Or it can strike it down on one ground and ignore the rest, which is probably what it'll do. And it'll probably be dual for cause removal.
Yeah.
That's my guess.
Yeah, that's the easiest one, I think.
That's my guess.
But either way, going to be a very significant case.
And one more quick sentence is the Consumer Financial Protection Board. There is an issue there that also was decided by the Fifth Circuit in terms of its funding. The Consumer Financial Protection Board is funded out of the Federal Reserve. The Federal Reserve actually just allocates, based upon a request from that protection board, allocates resources to the board, and the Fifth Circuit concluded that that was a violation of the appropriations clause in the Constitution, that only Congress can appropriate money to support an administrative agency, and so we'll see what happens there. Apparently in the oral argument, the Supreme Court was pretty skeptical of this, but you never know.
It's clever because it says there's actually no appropriations clause, right? It just says no appropriations shall be drawn from the Treasury, but in consequence of, or no money shall be drawn from the Treasury, but in consequence of appropriations made by law. No money is being drawn from the Treasury, right? They fund themselves.
Right. Well,
So
it's a
something-
roundabout argument.
Right, yeah.
Yes.
So it feels wrong, but that doesn't mean it is wrong. Or I mean unconstitutional, of course. Your feelings don't matter here.
There you go. All right, in our last topic here for a couple minutes before we turn to, I hope, a robust question and answer session, so be thinking about your questions. I want to talk about this issue of the Supreme Court and a code of ethics and the esteem or lack of esteem in which the Supreme Court is held these days. The American Bar Association has a very strong resolution in favor of the Supreme Court adopting a code of ethics. They are, after all, the only judges in the United States of America, the only ones who are not bound by any code of ethics. The ABA has not waded into the thorny separation of powers question of whether or not Congress can either impose one or tell the court that it has to impose one, because the House of Delegates is no smarter than this room on those issues. But clearly, the lack of a code of ethics is a significant issue right now for the court generally, and for those like all of us whose job it is as officers of the court to defend the court to some extent. I mean, I hope most lawyers don't ignore that part of our responsibility, if we can do it with a straight face, right, is to articulate that we support in a general way the Supreme Court. So, Steph, talk to us a little bit about what's going on with the court, with an ethics code, with their sort of stature in the eyes of the American public, and let's kick off about 5 minutes amongst all of us on this topic.
Sure. Well, I share Tricia's concerns, and what I suggested to her about this topic that might be of interest to the audience is that this is directly related to the court's legitimacy. And if you look around the world at I happen to do a lot of work in Mexico, those courts are always concerned about the legitimacy for reasons related to compliance. And the court's legitimacy depends upon the public's approval of the court. That's just a fact, right? In terms of whether the other two branches of government are going to comply with court orders, or whether the population is going to comply with court orders from the Supreme Court on down. And I can't help but notice, I looked in the Gallup recent polls, to look at the job approval rating of the Supreme Court, and you probably all know that its job approval rating is really at an all-time low, or at least an all-time low in modern history, down to a 40% approval rating from a 60% approval rating in 2002. That's a pretty precipitous drop in a fairly short period of time. Now, having said that, you also should be aware that there is a dramatic polarization, surprise, surprise, between who approves of the court and who doesn't. And that depends really on the most recent term. In many respects, Dobbs obviously created a surge of approval from Republicans. When the Affordable Care Act was upheld, that created a surge of approval from Democrats, and of course the other party went in the polar opposites. So the Supreme Court, sadly now, as in many other aspects of our politics, it is reflecting the polarization in the public. And so an ethics rule, seems to me, would be one way to bolster the public's confidence in the court that is now, at the moment, somewhat lacking.
Right, for sure. And clearly the nomination process is broken, and right, and we all know that. It is. It's not about, is anybody qualified, never mind the best qualified, but is somebody qualified to be on the United States Supreme Court? It's all about whether, if I nominate you, my constituents, right, are going to be happy with the results that you're going to drive when you get on the court. And we've always had some of that, but seems to me we have a little more than before. Justin, what are your thoughts on all of this?
I guess I don't know, excuse me, I don't know if there's a separation of powers concern. I'm not concerned about that. As a former government lawyer, that's what judges are, right? They're government employees. And I know that the justices of the Supreme Court wear robes, and there are only 9 of them, and they feel like magical creatures, but they are government employees, right? What is most worrisome to me is that there seems to be so much concern from inside the court on getting a simple ethics code passed, right? That may be why people are so jaded with the court, right? They can't sort of even regulate themselves. So I don't know. I don't know if it would be constitutional for Congress to pass a law to say, here's an ethics code. I'm just extremely disappointed in the court and the justices that they can't get it together to pass something to tell us that they're going to be ethical in how they do their job. That's my thought.
Well, Justice Roberts at the American Law Institute gala dinner in February, sort of said, we're thinking about this. This is really important. And
They're
we're
dropping.
thinking about that. And,
Yeah.
and a couple of other justices have said similar yada yada, maybe next year kind of things.
They're dropping hints. I mean, Roberts has said that. Justice Barrett recently said that. Justice Kagan has said that. Hints are not enough. They need to tell us the ways in which they're going to ethically discharge their job responsibilities.
So, I mean, they can't just live by the ethics code for all the other federal judges in the United States? What do you think?
I mean, they could, right? The question is, do they have to? And I mean, they already have recusal rules, right? They already follow certain recusal rules, and then they now, and which have changed recently because of criticism. And so I guess I don't know enough about this, and I'm like, what exactly in the ethics code would go beyond the recusal rules, and what exactly are they doing now that sounds so unethical? Because they might be doing things, right? But like going to a meeting of like-minded people, that doesn't bother me, you know. I do that. I can't have friends if I'm a judge, you know. A lot of people forget that the day after the Youngstown steel seizure case, where the Supreme Court invalidated Harry Truman's seizure of the steel mills, he went over to the justice's house to have a barbecue. And, you know, Harry Truman famously told, who was it? Was it Justice Black's house or something? And President Truman, famously said, maybe it's apocryphal, I don't know, but apocryphally and famously said, well, I don't much like your court decisions, but I do love your hamburgers, or something like that. And it's just like, you won't be able to do that anymore. And it's just like, I don't know, like I tend to be charitable toward people. I tend to believe that government agencies do try kind of to do their best, but I also recognize that they are corruptible, just like everybody else is. But they have certain recusal rules, and so I think it's much more complicated, right? But if you think that the Supreme Court's not going to be attacked anymore because they adopt an ethics code, that's wrong. That's wrong, because there's enough people in this country who don't like the judges on the court because of their political, ideological frame, the particular way they approach cases, and they will always be attacked. And that's my view. Now, if you want something concrete, that they've done this, it's not covered by the current ethics rule, and you should be an ethics rule, I have no problem with that. And I agree, I don't think there's a separation of powers problem, because the necessary and proper clause says Congress has the power to carry into execution its powers and any other power vested by this Constitution in the government of the United States or in any department or officer thereof, which department includes the judicial department. Right, so I don't think there's a separation of powers concern. Did Alito really say there was a separation of powers problem? It was like this Wall Street Journal op-ed that everyone was.
I don't know.
Yeah.
Yeah.
Yeah,
I don't
Oh,
know
he
if
did
he
say it was
meant
sensitive.
it. But I don't know if he meant it. I don't know. So I don't know. Those are my off-the-cuff impressions.
No, let's hope that's right. I mean, and certainly you're correct that the adoption of an ethics code is not going to overnight change the challenges that the court has with its current perception by the American public. But we have, it seems to me, a long history in our court systems of disclosure being a disinfectant. And that, obviously one of the problems that has come up is there was insufficient disclosure, right, on a number of things. And so even a more robust and enforceable, if you will, disclosure regime would, it seems to me, and it seems to the ABA, give more life to the notion that it's got some ethics rules.
Would it be enforceable, by the way? That's interesting.
Well, it would be
It's an interesting
self-enforcing,
question.
right? I mean, I don't think we can expect, the National Judicial Center to come in and knocking on the door of one of the court justices who breached an ethics code.
This reminds me of this case where, Justice Hugo, we mentioned Justice Black, he was unconstitutionally appointed, by the way. He was not a constitutional justice in the sense of, and there are other judges, I won't name names. There was one on the DC Circuit. There's an emoluments clause that's in the Constitution. There are 3, one of which says if you are a sitting member of Congress and as a member of Congress, you vote for the creation of an office or to increase the emoluments of an office, you are ineligible to be appointed to that office while you are serving your term. Justice Hugo Black was a sitting senator when the Supreme Court, a new law was enacted allowing them to retire at like 65 or whatever, take senior status and make lifetime pay for less work or whatever. The emoluments of the office increased, it seemed, and then he was appointed by it, and a challenge was brought, ex parte levet, and the Supreme Court miraculously decided that there was no standing to challenge Justice Black. Of course, Justice Black didn't decide that he was unconstitutionally appointed. So I just wonder how you would enforce it. Maybe though, if a lawyer to a case, or like if there's a case, like an actual party, didn't,
Impeachment is the way to enforce it.
That's a way to please
always
your
impeachment.
client. Excuse me, we have this whole other issue that we want to bring up to sidetrack you off of the merits of our case, but
Yeah, because if you bring that motion and they deny, which they will, like they're not going to be happy.
exactly,
You know, it's
right? If you're going to shoot the king, make sure you make it
yes,
work, right?
right between the
All
eyes.
right, well, this has been an extraordinary conversation. I want to open it up to all of you. We have just a few minutes left, but I'm certain there are good questions because I am looking at a lot of really smart people. So let's hear a question for this amazing panel. Tim.
Is there there's a microphone?
Tim, would you mind stepping to the microphone, because otherwise we can't record your question, believe it or not.
This is, of course, the editor of Arizona Attorney, and we are delighted to have you here tonight.
Well, it's a pleasure to be here. So when you talk about the respect that people have for the court, do standing issues that we've seen this term concern us, or should they concern the court about whether you really need a case in controversy, or I just need to be worried about a law applying to me? Should that trouble practitioners?
I think there's a lot to be said about the court's enforcement of standing and justiciability doctrines, Tim. I agree with that. In fact, I'm convinced, based upon a study I did many years ago, that justices vote to allow standing when they want to achieve a result on the merits to get that case in front of them. And I think that really is what's going on. Now, not across the board, but I do think that warrants that for enterprising students out there. This is a great paper to write for your senior thesis in law school. What do you all think? Do you think it's political, standing?
I will say that on pre-enforcement
When I say political,
injunctions, like the 303 creative case doesn't bother me. I mean, pre-enforcement
Yeah.
injunctions are routine. They used to not be. Okay, it used to be that if you wanted to challenge a government action or a government regulation or a statute, you would bring a constitutional defense. Okay, if there's an enforcement action brought against you, they would sue you, they would prosecute you, and you would defend by saying the law is unconstitutional and can't be applied. For better or worse, probably for the better, through a series of cases, Ex parte Young, Abbott Labs, over the 20th century, the courts decided that you don't have to wait to suffer these dramatic consequences. If the law pretty clearly applies to you, if the other parties agree that it applies to you, the Colorado Commission in the 303 creative case said, yes, we think you'll have to make a website for a gay couple and we will enforce it. And we reserve the right to enforce it against you. That's enough for most of these pre-enforcement challenges. If we think there should be less pre-enforcement challenges, then I think we should do it across the board. But I just find it very interesting that people, care about it all of a sudden when it's, a case that comes out the other way from what they want, which I think is often what happens. I mean, that's just human nature, I suppose. So I'm less worried about that.
Result-driven.
All right. I do think the state standing thing is weird because that's all over the map, right? Yes, Massachusetts v. EPA. No, Texas v. United States. Yes, MOHELA, the Missouri organization that operates the student loans. They're like, we don't care about this debt relief. But somehow Missouri had standing through that.
Again, that looks results oriented to me.
It does.
I'm sorry to say.
No, I mean, I think that, standing, like everything, can be results-oriented because it's just one of many legal issues. But there are always and there have always been manufactured cases. And this may have been one of them. I don't really know. But if it is a manufactured case, it wouldn't be the first. And there are lawyers who are looking to bring cases because they see a sympathetic court. And so I don't know, it does feel sort of distasteful, but I don't think that it's new. I think that movement lawyers have been looking for cases to bring for many years on all sides.
Actually, one of the first.
There you have it. Distasteful, but it's
One
going
of
to
the
happen anyway.
First
Sorry, I'm losing
Supreme
my voice.
Court cases reviewing an act of Congress for constitutionality was over a carriage tax, and whether it was a direct tax. And the parties agreed that the amount in controversy was satisfied. Somehow this guy had like 7,500, which is a lot of money, dollars worth of carriages. And it's like, no way. The guy probably had a carriage or something. But they just agreed, and no one
Right.
said
Question the
anything
facts.
about manufacturing
I
the
love it.
standing. So
We
it's
have time probably
1793.
for one more question before my voice completely disappears.
Yeah, me too, actually.
Well, I'm feeling great.
Yes, please, come
Two
to the
more
mic.
questions.
No, go ahead.
So correct me if I'm understanding this incorrectly, but with the Florida and Texas social media case coming up, that seems to be primarily about social media's ability to moderate their own platforms. Do you think that the creative precedent that was just set on expression could factor into social media's ability to moderate their own content and their own expression of what they want their content on their platform to be?
Who wants to tackle that one?
I'll let you guys talk right away.
Maybe. So
Maybe,
you're saying it's
yeah.
compelling YouTube or compelling Facebook to have a particular speech policy or whatever, and that's compelled speech?
Could that be a compelling argument?
I think it could, potentially, because it is requiring, under the language of the statutes, it is requiring them to explain themselves in various ways, and so I think it's possible.
You have a promising legal career ahead of you. That is a very creative argument. Right? I mean, there are situations like the Pruneyard case or something where courts have held that a state can require like a private shopping mall to allow leafleting, even if they didn't want it. And it's not their speech. And so Pruneyard is like the best precedent for the Fifth Circuit, I think, which upheld this law. So I have no idea what they're going to do, but that's a great argument.
One more question. We got about 3 minutes, so short question and short answers.
Okay, it's going to be a very short question and a very stupid question, okay? A non-legal disclaimer, I'm not a lawyer, I don't study law, I don't have a legal career in front of me, I'm an engineer. I'm just curious. This maybe idealistic, argumentative view of having a code of ethics for the Supreme Court. If we have one, who's going to enforce it? Just curious.
Yeah. Well, that's sort of my question, and I don't know. I think, Steph, your point was it's impeachment, but we know how impeachment works. We have impeached judges before.
Do we have?
A
Yes, we
judge
have.
by the name of
Chase?
Nixon. Walter Nixon.
That's right.
Not Richard
right.
Nixon.
But Sam and
It's a bad
Chase?
name, isn't it?
Yeah.
But he was acquitted, right?
He was
Yeah,
acquitted. He was
acquitted.
Pickering. Pickering was impeached.
Um,
He was a drunk, remember?
But he was removed?
I believe he was removed, yes. You have to check my history on that, everybody out there. But
So, but look, I guess a code of ethics gives grounds, right, that might not have otherwise been there for the impeachment, right? It gives grounds for the public to be upset if it's not followed, right? And in that sense, is it enforceable? And so, yeah, I don't know. It's a-
Well, and in
who
other
enforces the lower court?
Well, in other
ethics?
parts of our system, we
The
have
judicial conference
groups
does.
of judges
Judicial conference.
who enforce and decide upon, right, ethics violations by other sitting judges. So I think in this one, it would be the Supreme Court, right?
It's a
Having-
judicial conference, isn't it, Judge? Judicial conference is the body that enforces ethics codes against federal judges.
Way up to the top, it starts at the circuit level.
Okay. So it's self-enforcement in important ways.
Right.
And I guess they can do that because, why?
Because there's a code of ethics.
Yeah, but,
Code of ethics.
yeah,
and
but
the
what gives a,
Judicial Conference has adopted rules that say when you're. what
but
the
so
And
it
can
is
we-
the circuit court in which you are sitting as a superior court to your court
It starts there.
that gives authority to discipline?
No,
Or,
the authority to discipline comes from the judicial conference, but the process starts within
Right.
the circuits. And if they say, you could be, say, removed for disability. That's a good one. Physical, you can no longer discharge your office. You can eventually take it to the judicial conference, but I don't
Because
think
you know,
that's
my
happened.
formalist, you know, separation of powers question is, well, the judicial conference ain't exercising legislative power. It's not Congress. It ain't exercising executive power. It's not the president. It's not a court. So what power is it exercising? So I don't know.
It's a good question.
It's never, you know, didn't stop the sentencing commission.
But
Right.
presumably, no judge who has been disciplined has ever challenged that disciplinary action in court. I guess, right? Because
think-
otherwise, the constitutionality would have been tested.
I think that's right.
Yeah.
No, it's just
But I
challenged
think
in the
Ilan
system.
raises a good point. You know, but it hasn't been tested. It hasn't been tested.
The thing is that everybody either resigns or retires before that happens.
They're embarrassed.
Right. And there you have it. So please join me
Self-enforcing
in
norms.
thanking this amazing panel.
Before you all go, I just want to say one quick word. This was sponsored by the Center for Constitutional Design. Outside on the table, there are some additional pamphlets about some programs for the rest of the semester. We have another one on November 16th. If you're here for CLE, please be sure that Dottie Knox, who may be outside right now, knows who you are and has your contact information to provide you with that benefit. And I do want to thank Dottie Knox and Alina McNeil for making this possible. They're the ones who get everything squared away. And also note, just in case Carol is watching us or will watch us on TV, we did lose Carol McNamara as our senior director. Many of you know her. The flowers in the back are actually for her, but she wasn't able to come tonight. We lost her to Great Hearts Academy, so that's where she's gone. If you've missed her, and we wish her well and miss her very much. So thanks a lot for everybody for being here. Trish, thank you.
You guys are amazing.
There is that